So this topic is called recklessness. Couple of notes to annotate at the top of the handout. Recklessness is a form of mens rea. So for most, not all, but most criminal offences, D will be liable or guilty of an offence if he intended the offence or if he was reckless as to some possibility regarding that offence. So as you will appreciate with intent is very difficult to prove or establish in a court of law. And as a result, most defendants will be found guilty under the mens rea of recklessness if that's relevant to the offence in question. So if you look at all the non-fatal assaults, assault battery, section 47, section 20, D will be liable if he had intent for some possibility or if he was reckless as to a particular injury or possibility. So that brings us back to the point, what do we mean by recklessness? We know that for intent, D must have an aim and desire for an end result and know that that will occur to the point of absolute certainty. Also, intent encompasses oblique intention, where D may not have had an aim and desire for that end result, but at least must have appreciated that end result to the point of virtual certainty. So where D lacks that level of mens rea, if recklessness is part of that criminal offence, then D can be liable of the lesser MR of recklessness. Now, recklessness is a real sort of strange topic now because for 30 odd years, since the early 80s, the law has been very, very poorly interpreted. So there's been lots of bad decisions throughout from 1981, 1982. So this is something that's been hugely problematic for the courts. And then to add into that, it was very recently rectified by the House of Lords in a case you might have heard of, which is RVG and R. And the year of that was 2003. So although recklessness has been a huge problem for the courts, since 2003, in fact, it has now been rectified and settled. So really that brings me back to the question of how could this be examined in the exam, namely G153. Certainly it could be an essay, and there are two potential essays. Number one, critically evaluate recklessness, or some paraphrasing of that essay. The second essay that is possible is critically evaluate intention and recklessness. Okay, so there are two potential essays. Okay, so just looking at the start of the handout then. So for all crimes, defendant will be found guilty if he intended to commit the end crime. If you've got intention, then that will be an automatic tick that D will be guilty of that end crime. However, where intention is lacking, then for certain offences, most, not all, but most, D will be found guilty where he was considered to be reckless. So to decide, or for the courts and the juries to decide whether D was reckless, we need a test to apply. And that's been the problem since 1981-82, where the courts have been undecided as to which test to apply. So recklessness involves the taking of an unjustified risk. Historically, there have been two types of recklessness that have existed that have applied to different criminal offences. So there are two types that have existed: subjective recklessness and secondly objective recklessness. So now today only one of these exists. The only one that exists today is subjective recklessness. Objective recklessness was abolished in 2003 in the aforementioned case. However, this handout seeks to address the history of recklessness, the problems historically that have occurred, leading us to 2003 where the situation was rectified by the House of Lords. So this should be a very easy question for students to answer, as it's something we've addressed throughout the full year of criminal law. So question: what is the difference between a subjective and an objective test? Well, really, you should know that answer 100% without me having to say, but just to recap, subjective is D's perception, so what D foresaw, what D appreciated in the given circumstances, whereas objective is not D but the jury's perception and what the jury would have foreseen in that given set of facts. Now, generally speaking, subjective is the fairer test of liability. Objective is deemed to be unfair, and an unfair way and means of testing D's mens rea or foresight, because you're not really looking at D's foresight, so that's why it's unfair. It ignores age, mental disabilities, low IQ, etc. But then subjective is not perfect because that's too easy to abuse. But overall, on balance, subjective is the fairer test of liability. Okay, so question. With recklessness, we know that D must have taken an unjustified risk. Well, day to day, every single one of us takes a risk. For example, if you drive to college, that is taking a risk. Crossing a road, you are taking a risk. Placing numbers on the lottery, you are taking a risk, etc. I could go on. However, that wouldn't be enough to justify criminal liability. What we're looking for, whether it's subjective or objective, is that D has taken and adopted an unjustified risk. So what we're looking for here is question: what is an unjustified risk? This is a risk where the potential harm is greater than the social utility. So for example, undergoing an operation to repair a tendon. With any surgery, there is a risk of infection, of injury, death, etc. But that certainly is a justified risk because the risk is very low and the utility is very high, that you're going to repair somebody's tendon, somebody will be more healthier afterwards, after the operation. Whereas me driving to work 20 miles over the limit, the harm is very high, the utility is low, so that would be in criminal law an unjustified risk. So very much similar to the area of consent, where the courts are seeking to address harm versus social utility. The courts will balance both factors, harm and utility, and in doing so be able to decipher whether or not the risk undertaken was a justified or unjustified risk. Okay, so next question: what problems have existed with recklessness? Well, just referring to the above points, the courts have struggled with whether recklessness should be tested subjectively or objectively, and for a moment in time, for quite a number of years, for around 20-30 years, both applied. Some offences were subjective, some offences were objective, and some swapped between the two. So the courts couldn't decide two things really. Number one, which test should we be using, sub or ob? And number two, which applied to the different criminal offences, criminal damage, assaults, manslaughter, etc. So really it's been a mess since the early 80s. So there's been a problem since the early 80s till 2003, so a good 20 odd years. So the recklessness timeline. Okay, so got a small amount of space there, but if you could just sort of draw a line, draw a wiggly line, or if you've got a ruler, draw a line there. If we could get a timeline there, right at the left hand side, it needs to start with the 1950s, leading through to the 1960s, 1970s, 1980s, and then to 2003. So on the left hand side, somewhere here, you should have the 1950s, 60s, 70s, 80s, 90s, leading here to 2003. So the recklessness timeline, and in short, this is the recklessness essay, critically evaluate the historical chronology of recklessness. Okay, right back in 1957, recklessness was born. It was the first time that recklessness ever had a criminal meaning rather than the everyday sense of the written word. And in 1957, it was the birth of subjective recklessness. So that was born in 1957. Now, that was the only form of recklessness that existed until the early 80s. So somewhere around here, wherever you put 1980s. So it's 1981-82. The case in question began in 81, finished in 82, so it's quoted as both really. But so in 1981-82, we had the second birth, which was the birth of objective recklessness. So from 57 to 1981-82, we've just got one test there, which is sub. 1981-82, we've got two tests: subjective recklessness and objective recklessness. So then the grey area and the big area of concern is 1981-82 to 2003. So for this 20-year period, both coexisted, and offences changed from sub to ob to sub. There was a huge popularity with the objective test, so subjective became less popular, and then that became reversed the closer we got to 2003. So in short, we had a 20-year period of uncertainty, subjective and objective both in operation. So critically evaluate recklessness, that's the essay just in a couple of sentences. It started out in 57, it was good law, it worked, it tested culpability, it tested fairly liability. 1981-82, 2003, bit of a car crash, an absolute mess, yeah. So the courts were moving between the tests, and objective, courts soon realised, was a very unfair test of liability. Critically evaluate recklessness today, there is no issue. Objective recklessness has gone, and the best test, which is subjective recklessness now, is the only form that exists. So today there's very little to critically evaluate unless you're looking at the history. Okay, so here we go. So the rest of the handout really is tracking the chronology from the very start in 1957 to the very end in 2003. Okay, so the birth of recklessness in 1957. So prior to the case which created subjective recklessness, which was the case of Cunningham, 1957, recklessness did not exist at all in English criminal law. However, in this case, the Court of Appeal made a landmark, really important judgment and created a new form of mens rea for the first time ever, which is not just a change, but a massive change in creating a whole new form and type of MR. And this mens rea was called subjective or Cunningham type recklessness. Now, whichever phrase or name you utilise, it absolutely does not make a single difference. So some students call it subjective recklessness, some students can call it Cunningham type recklessness, some students call it subjective Cunningham type recklessness, and actually it really doesn't matter. I would at some point in the script refer to Cunningham and subjective recklessness so the examiner appreciates you understand both key phrases. Okay, so to understand where this came about, we need to appreciate the facts of Cunningham. So this was 1957, so the defendant ripped a gas meter from the wall in order to steal the money inside. So we're going back a long, long time. In the 50s, it seemed that people put coins into meters for gas, electric, so it wasn't quite like today where you have bills and things like that, direct debits, so people put money into the gas or electric meter. So he was really keen to get the money outside the gas meter. So he pulled the meter off the wall. Now when he did so, he ruptured a pipe and gas leaked into an adjoining flat, which injured the woman that was living in the adjoining flat. In fact, the lady was his mother-in-law. So she survived, and Dee was charged with Section 23 of the Offences Against the Person Act 1861, which is called maliciously administering a noxious substance so as to endanger life. Now, when you look at the Section 23 and you look at the OAPA, the Act is classically described as being archaic, massively out of date, terminology that we would not use today. And in addition to that, with it being a codification act, there is very little definition at all regarding the offences against the person, the assault, and here Section 23. So there was no section in the act that said the mens rea for Section 23 is. That just didn't exist. So what the courts had to do in order to convict was identify the mens rea for this offence. So identify it, then they would be able to apply it, and then decide whether Dee was guilty or not guilty. So the only mens rea type word that featured in this particular section, Section 23, was the word malicious. So what the court ascertained was the mens rea was tied in and locked into this word malicious. So malicious indicated the mens rea for the offence, hence the meaning of that word was crucial to the case and whether Dee was guilty or not guilty. So in short, the court had to define the word malicious and then apply that to Dee. Now, I'm sure you will appreciate from previous classes that recklessness is one of the hottest topics of the year for an essay. So it's not quite at the top, but it's very, very close to the top, i.e. it's just not been examined for a very long number of years. So for those that are more likely, and any essay can come up, absolutely any essay, there will be a cold essay. So I'm not trying to predict the exam. All I'm saying is certain essays, we need to do a little bit more with judicial reasoning, trial judge, court of appeal, House of Lords, and just do a little bit more with those because they're more likely. Although, again, like I say, a cold topic probably will come up. It's just that we do a little bit more with essays that haven't come up for a number of years. So here we go. So a little bit more judicial reasoning, just because it's got a better chance than some of the other areas, but it doesn't mean it will come up. Right, so the trial judge. The trial judge held that the word maliciously meant wickedly. So that was applied and Dee was convicted. So Dee therefore appealed. Now the trial judge has misinterpreted that because maliciously doesn't actually necessarily mean wickedly. However, of course, the trial judge was just doing his best in an act and a section that was not defined. So Dee appealed, and the Court of Appeal held that maliciously meant the following. Did Dee intend that V, the mother-in-law, inhale the gas, which is intention? So did he have an aim and desire and know that V would inhale the gas? Or, number 2, had Dee foreseen the harm, the risk, but yet still continued with that risk? Just to paraphrase that, the Court of Appeal is saying maliciously means Dee must have intent or be reckless. He saw the risk of harm, he appreciated that existed, but yet still continued with that risk. What they've done there is define and create subjective Cunningham type recklessness. And that's the one that still exists today and applies to the assaults and many other offences. Okay, so the Court of Appeal concluded that recklessness was the relevant test and therefore maliciously referred to a person who knowingly undertook an unjustified risk of harm to another person. So it's not just a risk, it's an unjustified risk. So this created subjective or Cunningham type recklessness, i.e., number one, did D foresee a risk of harm and run that risk? And two, was that risk unjustified? Now, just because this is an area that's not come up in a long while, the test for Cunningham and the second test, which is called Caldwell, you need to really know sort of word for word or as close as to the actual definition. So number one, did D foresee a risk? And did he run that risk knowingly? And two, was that risk unjustified? So subjective recklessness was born, in short. Now, after Cunningham, for many years there was just one form of recklessness in criminal law, which the courts began to apply to many other criminal offences. So if you just put next to the word offences, just some examples, but there were many, many more. The assaults, full range, criminal damage, subjectively tested, manslaughter, etc. So the courts realised it was a good test for any defendant lacking intent, was looking at their culpability, their foresight, and it was used time and time again. So an example of that was the case of Venner. Venner is a case which features on my assaults handout. Might not be on the other classes handout, but that doesn't matter because it's a case in principle for judicial reasoning. So the case of Venner, which was a section 47 ABH of the Offences Against the Person Act. So the Court of Appeal in this case added subjective recklessness, brackets SR, to other offences under the OAPA. So the Court of Appeal is saying, look, what we've created in Cunningham we like, and they applied it to section 47, which was now to be tested subjectively. So we're still in 1957, so at this time the only form of recklessness that existed was subjective recklessness, or Cunningham type recklessness. Now, if you were to ask any criminal lawyer or any lecturer of law, which criminal offence created or triggered the problems with recklessness, the person in question that you ask will return with two words: criminal damage. Criminal damage was the offence that created the problem in the early 80s. Criminal damage was the offence that rectified the problem in 2003. So really most of the cases that have created the bigger problems for recklessness have been criminal damage. So that's where, therefore, it's important to kind of look at criminal damage in a little bit more detail. So, as a result, looking at the Act which governs criminal damage, which is the Criminal Damage Act 1971. So, the Law Commission, which created the new Criminal Damage Act in 71, whilst working on the creation of the new criminal damage offences, reported that the Cunningham definition of the word malicious was correct. Furthermore, it added that for criminal damage, D must have intent or be reckless as to the end criminal damage. Okay, so what we're saying here is the Law Commission. Now, the function of the Law Commission is that they go away, they do the research from top lawyers and academics. Then they come back with their proposals, which go to and from various different bodies, they go through various stages, and then they conclude after various different drafts the final proposals which then get passed to Parliament. If those proposals then become law, that means most of the recommendations were agreed, affirmed, and therefore the vast majority then flew through Parliament and then became part of the new Act. Now the problem is, of course, the Law Commission and its proposals are not binding. They are persuasive. Why? Because not all of them will have been implemented through the parliamentary process. Some might have been amended, some might not have been adopted or tweaked. It does give you a fair representation of what Parliament intended, because if Parliament did not like most of the proposals, it would never become law. So it's safe to say that whatever the Law Commission wrote in its final report, the vast majority of that must have been the intention of Parliament. So what we're saying there is, on that first 3 lines, that in the Law Commission report, in short, it says the mens rea for criminal damage is intent or subjective Cunningham type recklessness. That is clear, yeah? And it's the only thing that existed at the time in 1971. So I know 100% Parliament intent was intent, and if not intent, subjective Cunningham type recklessness. Question: therefore, what was the problem? The problem with the Criminal Damage Act is in the Act it just uses one word, the word reckless. Not subjective recklessness, not Cunningham type recklessness, just the word reckless. But of course, at the time, only one form of recklessness existed. So it was clear, looking at the Law Commission report, and the fact that at the time only one thing existed, when it said the word reckless, it meant Cunningham or subjective type recklessness. 100%. So the Act did not define recklessness at all, but again, really, it was pretty clear what they were referring to. Subjective Cunningham type recklessness. But the problem was, and this is where the problem arose, because it didn't define the word reckless, it left open the possibility for the House of Lords to play about with that word and create a second test, which is where the problem started. But it was all about criminal damage. So, however, we'll come back to that. Stevenson, 1979. So this was a criminal damage case, and this was before the problems arose in the early 80s. So this is where still only subjective recklessness existed. So Dee was a schizophrenic, and he was a homeless man who was taking shelter in a haystack on the North Yorkshire moors, and he lit a fire with some twigs in order to keep warm, but it quickly caught fire and caused quite a lot of damage. Now, as a result of his schizophrenia, the defendant had been deprived of any normal ability to perceive and foresee risk. So this was crucial, whether or not this defendant was tested subjectively, because that's his perception with his schizophrenic tendencies, or whether he's tested objectively, which did not yet exist, which would mean the jury who are not schizophrenic. The Court of Appeal upheld Cunningham, clearly by looking at the Law Commission report, the fact that only SR existed. So upheld Cunningham type recklessness for criminal damage and acquitted the defendant. The defendant was not guilty because, as a result of his schizophrenia, he did not foresee a risk of damage, so he didn't foresee an unjustified risk of harm. So just to make that clear, next to the name of the case, we'll just write some key notes. Stevenson, 1979, CD, criminal damage, CD, equals SR. Because soon that changed. Soon that changed pretty quickly and changed for a long, long time. But at this moment in time, criminal damage was tested subjectively. Now you can argue that positively and negatively. You could say, on a positive, He did not foresee the risks, therefore his culpability was low. And indeed, to put him in prison is not going to correct his behaviour, and it certainly wouldn't prevent him from doing the exact same thing again. On the negative, you could argue that how is that protecting society? That this is a man who set fire to a haystack, could have endangered life, property, etc., yet has escaped liability. But overall, I think I would probably go with the fact that it's a fair test of liability. You're looking at culpability, and this is a defendant who lacked that culpability. Right, here we go. So this is where the problems arose. The second test, which was the case of Caldwell in 1981. Like I say, in the textbooks, some say 1981, some say 82, and that's because it crossed over both years. Okay, so the House of Lords were asked to consider the issue of recklessness in context with criminal damage in the case of Caldwell. So the facts. So the defendant was an ex-employee who'd been sacked from a hotel. He'd been dismissed, so he had a grudge against the owner of the hotel. Now, Caldwell was extremely drunk, so he broke a window and he started a very small fire on the ground floor. It was in the foyer of the hotel. The fire was quickly discovered and it was quickly put out and extinguished, and no serious harm was done at all. Dee argued that he'd been so very drunk that he'd not realised that there'd been any endangerment to life. So the defendant, however, was charged with criminal damage with intent or whilst being reckless as to endangering life. So there are various different forms and types of criminal damage. The most basic one is simple, basic criminal damage. So if I were to smash a window, that's basic criminal damage, which is quite a low level ranging offence. This is a very serious one. Criminal damage, but with intent, knowing, or at least being reckless as to the endangerment of life. So it's a very serious label and sentence. So what Dee is arguing is that because he was so drunk, he didn't realise the second element of the offence, that he hadn't realised the possibility, i.e. he wasn't reckless as to endangering life. So this got up to the House of Lords in Caldwell, and the main judge, now this is going back obviously many years, so at the time one main judge would deliver judgment, and this was Lord Diplock. So Lord Diplock, what Lord Diplock should have done is apply Stevenson, apply the Act, which by inference indicated subjective recklessness, and the fact that at the moment in time only one form of recklessness existed. What Lord Diplock should have done is apply subjective Cunningham-type recklessness. But, I mean, this is just my opinion, but clearly the House of Lords were hell-bent on convicting this defendant. So they were willing to do whatever they needed to do to convict this defendant, because there was a risk if you apply subjective Cunningham-type recklessness. If he was really drunk, he might not have taken subjectively an unjustified risk. And if that was accepted, then of course he would be acquitted. So the House of Lords were not willing to take that risk, and so created a second type of recklessness. The second form of recklessness was known as objective or Caldwell type recklessness. So if the Act, now this is Parliament totally at fault, if the Act had just had one extra word included, the word subjective, this could never have taken place. So really Parliament are completely at fault by not defining the Act sufficiently. However, House of Lords have been a little bit naughty really in doing what they did here, which is create a second type of recklessness. Remember, the function of the House of Lords is not creation of law. They interpret, and here they're creating a second type of recklessness. Now, so This form of recklessness only applied to criminal damage at this moment in time because this was a criminal damage case. So defendant would be objectively reckless if. Now, unfortunately, you're going to have to learn this almost word for word, or as close as to the possibility of. Especially when it's an area that hasn't been up for so long, it's one that you need to be quite close to. So for many, many years, students have kind of given me a version which is nearly there or nearly not there, or the last couple of years, because it's not been up so long, I expect that students need to just learn this definition verbatim. It's a couple of lines. So, a defendant would be objectively reckless if D created an obvious and serious risk. Now, I've just put there and serious risk because that came afterwards. The and serious was added very shortly afterwards. But this is the definition as it is today, or was before it was abolished. So D had to create an obvious and serious risk, which either, so you had to tick either the next bullet or the third bullet. So either D was unaware of the risk, not given any thought to the possibility of a risk, but the ordinary prudent individual would have foreseen that risk. Or D saw the risk, recognised the risk, and nevertheless continued with that risk. Now, so what this is called is the Caldwell test, and it's also called a two-limbed test. So limb as in arms, L-I-M-B. So the two limbs of Caldwell. Limb 1 is this one here, and limb 2 of Caldwell is this one here. Okay? So we've got two different limbs. One of the limbs is absolutely spot on, not a problem at all. However, the other one is quite the opposite. So here we go, a couple of notes to add. Number 1, next to the name of the case, created OR, objective recklessness, or CR for Caldwell recklessness. And then a couple more notes. So your two limbs of Caldwell, so this first limb here. So D was unaware, not thought about the possibility of a risk, but the ordinary prudent individual would have foreseen the risk. So a couple of notes off here. So this is the objective limb of Caldwell. OB, objective limb, LIMB of Caldwell. Another phrase for this part here, which we'll come back to in a second, is the inadvertent risk taker, which is just down here. We'll come back to that in a second. The second limb of Caldwell is where D recognised the risk and nevertheless continued with that risk. That's a subjective test. In actual fact, that is subjective Cunningham type recklessness. That one is fine, there's no problem with that test at all. If you saw a risk and you ran it, you are culpable. So it's a very fair test of liability. So effectively what the House of Lords have done is picked up the subjective test, Cunningham, added this on top. This is good PP, it's a good test. This is not. Yeah, that's a very unfair test of liability. You're not looking at D's foresight, perception, age, IQ, mental faculties, etc. So that is the whole problem with the Caldwell test. Okay, so that's the test. So as a result, Caldwell could be convicted on the facts, as he had been objectively reckless in endangering life, and it was irrelevant whether D had considered or had foreseen any risk to life. So in other words, what Caldwell had said is, I was really, really absolutely blind drunk, so I didn't see a risk. However, he was convicted under Limb 1. He might have been unaware if he was really, really blind drunk, or he might not have thought about the possibility, but the ordinary prudent individual, which is a fancy way of saying the reasonable man who isn't drunk, would have foreseen a risk, setting fire to a foyer of a hotel, that could endanger life. So he was convicted under that. Now on the facts, that's fine. You've got somebody there who's getting willingly, voluntarily getting very, very drunk, setting fire to somewhere where he's been sacked, which could have caused mass damage and could have killed. The fact that he's convicted, absolutely spot on. But the test as a whole, not very good. VBAD, yeah? Because of this limb here, you're going to convict defendants in other cases where they have low IQ, children, mental problems, etc. So what they've done, what they do best, the House of Lords, tunnel vision, they've created a test to convict a defendant, not thinking about the bigger picture of how that would impact on other defendants. So D was convicted and they created the test. Okay, so Caldwell recklessness sets out to convict two types of defendant, both the advertent and the inadvertent risk taker. Should this be the case? So this might make resonance with the previous topic of gross negligence manslaughter, and we talked about this. There are two types of risk taker in criminal law: the advertent and the inadvertent risk taker. These defendants are so polar opposites apart. These are two totally different types of defendant. One is not culpable at all. The other one is extremely culpable. So you've got the advertent risk taker. The advertent risk taker is somebody who saw a risk, knew that the risk was there, appreciated the risk, but still continued. That defendant is 100% absolutely culpable. He saw the risk, he ran it, regardless. That defendant should always be guilty. The inadvertent risk taker is the defendant who saw nothing, appreciated no risk, foresaw no risk, and appreciated nothing. The culpability of that defendant normally, not always, but normally is extremely low. Especially if it's a young child or somebody with learning difficulties or low IQ or mental problems, depression, schizophrenia. Lots of different types of defendant who do not see a risk for various reasons. The inadvertent risk taker often is very, very low in levels of culpability. So just on your third bullet point there, the problem with the Caldwell test is that both are considered and dealt with equally. Both are guilty. Saw the risk and ran it, v culpable, prison. Did not see a risk, for whatever reason, you're still dealt with in the exact same way and you are guilty of the same offence. So should that be the case, that both are convicted under Caldwell? Absolutely not. This defendant is extremely culpable. This usually is very, very low in culpability. Caldwell treats the same, the both as absolutely the same. Saw the risk, didn't see the risk, still get the same convictions. Both are found guilty and both are given the same conviction, same sentence, which is absurd, which is unjust, which is just wrong. The problem, of course, is this one. The inadvertent risk taker culpability is not sufficient. So just a couple of other points just to ratify fully the objective test. Which test of the two is easier to prove? Again, these are kind of issues that we've talked throughout the year, so this should be no surprises here. Objective is clearly so much more easier to establish. Subjective is very difficult to establish because you're looking at D's perception, D's foresight. And if you're looking for D's foresight, well, only one person will appreciate that, and that is D. So D could lie, but even if D is lying, not lying, how do you prove what D foresaw at a time? Whereas objective is far easier to prove because you're not examining D's mental makeup or his foresight, what he foresaw at the time, because the jury are deciding what they would have done at that particular moment in time in the given set of circumstances. So even though objective is easier, it really doesn't justify imposing the objective test. It just gives us more AO2. Okay, last question on this side of the handout. How did Caldwell affect Stevenson, which is the case further up at the top of the handout. Stevenson was the schizophrenic homeless person who had set fire to the haystack. He was charged with criminal damage. And as we said at the top of the handout, he was found not guilty because he was tested subjectively under Cunningham-type recklessness. Now the law had changed and criminal damage was now to be tested under Caldwell, i.e. objective recklessness. So how did Caldwell affect Stevenson? The defendant who was found not guilty would now be found guilty under the first limb of Caldwell. The ordinary prudent individual would have seen a risk of setting fire to the haystack because the ordinary prudent individual would not have his mental condition, i.e. schizophrenia, which seems very, very harsh. Convicting Stevenson in the first place and up to a life sentence seems extremely harsh for a defendant who, it was established in court, could not perceive the risk of harm. So the law had now changed. Okay, so this was a major precedent, the decision of Caldwell, in creating a new form of recklessness, in creating a new form of mens rea. Making such a major decision, the laws have to justify why they have done that and justify the reasons and foundations for that decision. So just a couple of points to note in order to criticise the justification of the law lords. First of all, the decision of Caldwell was a 3-2 split, a 3-2 majority. We know now, looking at many decisions throughout the year, most of the poorest decisions in criminal law are 3-2 splits. This is because two law lords who were the height of the legal profession, the most experienced practitioners of law in this country, have said that this is not a safe decision. Now, as I've mentioned before in previous lessons, when you're looking at jurisdictions such as Australia, Canada, New Zealand, who cut and paste our criminal legal system, because I know we criticise our system throughout the year and we have to for the exam, but actually it's a pretty good legal system. So what they did, they cut and paste our legal system, but a couple of points that didn't quite work, they've not adopted, and that is one of them, a 3-2 split. A 3-2 split should never, ever, ever be law, ever. Because just one law lord deciding differently, the result would be a different way. So that's not safe, and it's not right that it creates a new precedent, and certainly not a new form of mens rea. So the next 3 points, 3-2, normal word, inadvertence. This is all judicial reasoning, so this is good stuff and required for this essay. So 3-2 split, so that's a bad decision, it's a weak majority, which should not be binding. So if you can remember the name of the judge, if not, then don't quote it because you'll lose all credit for the case. But Lord Wilberforce, Wilberforce, and Edmund Davies, who we saw in burglary in Collins, both Lord Wilberforce and Lord Edmund Davies dissented. So Lord Wilberforce was quite a senior judge. Well, he was a law lord for a start. But Edmund Davies, he was, one of the most renowned judges. So when both of those are dissenting, that's not a safe precedent. Right, so another point of justification from the law lords in doing what they did, i.e. create objective Cunningham type recklessness. Now, this was a comment in the judgment, and this just does not bear logic or make sense. In the judgment, the law lords referred to recklessness and said that recklessness is a normal word for the jury to decide. So just write that down next to normal word, that the law lords, this is the majority, said that recklessness is a normal word for the jury to decide. They followed that up with a funny word, but it's quite a good word, and it certainly will be impressive for the examiner. That it's a normal word for the jury to decide, having no esoteric or special meaning. So having no esoteric or special meaning. I'll spell esoteric, esoteric, esoteric. Now, what esoteric means is a special meaning. No test, no special particular meaning. So in effect, what the law lords are saying here, or the majority, is that recklessness is just an everyday word. Whatever they were doing in the precedent, it was just an everyday word which the jury can understand and apply. Well, somewhere around that section there, that absolute craziness, what the law lords have done in this case is create a very specific three-part test. So the two limbs plus the first part, which deem must create an obvious and serious risk. Number one, the inadvertent limb. Number two, the advertent limb. That's just absolute, does not bear logic at all. How can it be an everyday word for the jury? How can it have no esoteric meaning when you've specifically set a very, very specific and defined three-part test? So that just doesn't even bear logic. It clearly does have an esoteric meaning because you've just defined a test and create a whole new form of mens rea. So the fact it's 3-2 split, it needs to go in the bin. The fact that they're saying recklessness is an ordinary word, well, it's not. You've just created a test. It clearly has a different meaning to the everyday word, and you've set a specific test. So another reason why this should never have been law. Thirdly then, so in terms of how convincing the decision was reached by the law lords, this decision and this test is saying the inadvertent risk taker, so being inadvertent, is as culpable as somebody who runs a risk and knows it. Just give that many question marks. There's no person in the world that can objectively look at that and say that is accurate. Somebody who does not see a risk is never in the same league as somebody who saw a risk and still ran the risk. The culpability is vast. So therefore, the whole level of convincing nature of this precedent is pretty much next to nil. It's 3-2 split. The judgment is saying recklessness is a normal word. It clearly isn't. And the fact that they're treating inadvertence the same as advertence, yeah, that is just wrong. It's not justice. It's unjust. Okay, so further AO2 regarding the precedent of Caldwell. We've got J.C. Smith, top academic. We know him back to front. We've seen him lots and lots of times, J.C. Also another top academic, not quite J.C., but Glanville Williams, looked at Lord Diplock's judicial reasoning, and look what Lord Diplock had said. And said the following, that the judgment was regrettable and pathetically inadequate. Now, bearing in mind J.C. Smith and Glanville Williams were top lawyers and top academics, that's quite strong language. What they're trying to say is it's not good. Well, more than that, they're saying it's really, really shocking. That the whole judgment is regrettable and pathetically inadequate. For a legal academic, that's strong language to use. So that's not a good sign either. So ultimately, at this moment in time, we've just seen the birth of objective Caldwell recklessness, What happened to subjective recklessness at this time? Nothing. The answer is nothing. They both coexisted. However, what did happen initially is objective took off. The judges thought, wow, this is a great new mens rea. And so it became the bee's knees, it became popular, and judges kept switching offences from subjective to ob, sub to ob, and subjective recklessness became unpopular. So the shift was very much to this new Caldwell test. Only for a number of years, because it didn't take long for them to realise exactly what had taken place. Okay, so Caldwell had just been created, but later that same day, Lord Diplock, same leading judge in the House of Lords, was involved in another case which also involved the issue of recklessness. So this is Lord Diplock on a complete mission, in one day making 2 major changes to the criminal law. So this case is the case of Lawrence. So this is 1982. Defendant was a motorcyclist and he was driving at speed. Now this is not just at speed, but excessive, huge excessive speed, 80 miles an hour in a 30 mile per hour zone, and he killed a pedestrian, and he was charged with an offence which no longer exists, but because it's not on the syllabus you don't need to reference the offence specific. So if you start to talk about different driving offences, then you could lose credit for all case. So either get it exact or just put a driving offence. Yeah. So Lawrence was charged with causing death by reckless driving. So the House of Lords upheld the objective test. So they picked it up and they applied it to this decision and applied it to this offence. Now really, if you can try and be exact, I would try, because it's such a key case. It's the same day as Caldwell. So causing death by reckless driving, suddenly that was added to Caldwell, and the test was Caldwell objective recklessness. I.e. it was irrelevant as to whether D had foreseen a risk of death and continued with that risk, because under the objective limb, the test was this: would the ordinary prudent individual have foreseen a risk of harm, having driven 50 miles above the limit? So next to the name Lawrence 1982, just keywords there: reckless driving equals CR, Caldwell recklessness, or OR, objective recklessness, whichever way you want to define it, doesn't matter which one. Okay, a couple of points to add to that. The House of Lords added the word serious. So remember the original test, you've got 3 bullet points. First bullet, then limb 1, limb 2. First bullet is D must create an obvious. The House of Lords added in this case, which was just hours later, and serious risk. So D must have created an obvious, which was Caldwell, and serious, which is Lawrence, risk. Reflecting that motor manslaughter, and that's another way of describing the offence, another way you could get away with defining this offence. Motor manslaughter is far more serious than criminal damage. So driving 50 miles over the limit is more serious than criminal damage, setting a small fire in a foyer. The wording had to be changed since it wasn't criminal damage but motor manslaughter, which is more serious. Setting a fire which is put out pretty quickly, or driving 50 miles over the limit which kills, clearly that is far more serious. So the House of Lords amended and adapted the test, and that's a problem in its own right. You've created a test in the morning, and suddenly hours later Lord Diplock is changing the test again and adding more words. Well, that just doesn't make sense, and that's confusing and not good law. So there had been a misdirection in the trial court, and the jury were misdirected, hence D was found not guilty. So later cases demonstrated and confirmed that objective recklessness, objective test, now applied to many more offences. Okay, so in short, what happened is that Caldwell had created Caldwell recklessness. Lawrence had applied it to a different criminal offence in the afternoon. So it was created in the morning, it was extended in the afternoon to causing death by reckless driving. And what happened thereafter is that the courts added it to further offences. So it kept getting added and added to different criminal offences. Because at this moment in time, the House of Lords and the Court of Appeal thought this was a good test. So they applied it to further offences. So in the case of Reed, 1990, Dee was driving his car along a busy road near Hyde Park in London, and he undertook a car on the inside lane, which is illegal, and at speed, and he hit a taxi hut, killing the passenger in the vehicle. Now, Dee was charged with causing death by reckless driving. The House of Lords upheld the conviction using the Caldwell-Lawrence direction. So that's really what in a lot of textbooks they referred to objective recklessness. It became known as Caldwell or Caldwell-Lawrence type direction, stating that although Lord Diplock had defined the model direction in the morning and then amended it slightly in the afternoon, it was not necessary that the courts had to stick to or adhere to the exact wording in order to allow the test to fit to each case and each offence. So what the court are saying here, House of Lords are saying, is that however you phrase it, you can paraphrase it, as long as you're sticking to the gist of the objective test, then that suits this type of recklessness. Well, that's not really good practice, really. That's just confusing for the trial judges. What you're really looking for is one test that's exact and that the judges stick to it. So again, that's not great guidance from the House of Lords. So the trial judge in the case had correctly used the Caldwell-Lawrence direction. So the appeal was dismissed by the defendant, who was then found guilty of the offence. So just to make that clear, next to the title Reed 1990, reckless driving or causing death by reckless driving equalled OR or CR, Caldwell or objective recklessness. So I've kept the driving cases together, and now this was the case where it started to unravel. So there was a few key cases in the early 80s where the judges began to question the validity of this objective test. So in Seymour, and we've looked at this case on the GN manslaughter handout. So this was a manslaughter case. Dee had been arguing with his girlfriend, and he was in his lorry and she was in her car. And then they'd clipped each other's vehicles, and she'd got out of her car and he squashed her into the side of the road, the barrier. But Dee had explained that he'd been trying to free his vehicle from her and that he'd not in fact seen the victim, his girlfriend, at all, having squashed her against the barrier in his car, his lorry. The House of Lords convicted of involuntary manslaughter, so that's gross negligence manslaughter, and used and picked up and adopted Caldwell recklessness. So this was Lord Roskill. And it was held that Dee had created a serious risk, which was an obvious one, which the ordinary prudent individual would have foreseen. Now, let's get this straight on the facts. Fine. This is a defendant who, in short, very much, the evidence is pointing to the fact that he was annoyed with his girlfriend and he crushed her with his vehicle. Very much looks that that's the facts of the case, i.e. very culpable and deserves a conviction of manslaughter. But forget about Dee. Think about the bigger picture, what this is doing for the criminal law. What this is doing for the criminal law is saying that manslaughter is to be tested objectively. Well, some would argue that no crime at all should be tested objectively. ignoring D's foresight, his IQ, his mental makeup, etc. But manslaughter, up to a life sentence, one of the biggest labels you can give to any person at all. Manslaughter, you have killed a human being. To test it objectively is unjust. Completely unjust. On the facts, fine. And I think if they tested subjectively, they could still have convicted. Surely you must have foreseen a risk, and still continued. However, that's not the approach the House of Lords adopted. So Lord Roskill held that the Caldwell-Lawrence direction, i.e. objective recklessness, now applied to all offences unless otherwise specified by an Act of Parliament. So that was obiter, but that's absolute craziness. So not only are they picking up this test and adding it to further crimes, Lord Roskill is now saying it's everything, unless Parliament have said differently, and of course you've got to follow Parliament's intent. Unless Parliament have specifically said that a particular offence is a level of mens rea, then Caldwell-Lawrence objective recklessness applied. This is just the House of Lords going mental. Everything now was objectively tested. And it's not a good test, it's unfair, it's unjust. However, this was not an error, because the House of Lords picked up these exact words again in a further case of GN manslaughter, invol manslaughter, in contra quam. Caldwell recklessness was again upheld. So there was no surprises here. The House of Lords were loving this new test. They did not think it was unfair. They thought it was a great test. And they was applying it and extending it to as many criminal offences as possible. So the popularity of objective Caldwell-type recklessness continued in the case of DPPVK 1990. So this was the case that featured on the assaults handout. So this is a section 47 case. So this was a defendant, a 15-year-old boy, who wanted to take this sulfuric acid from his class in order to test the reaction of the acid with some toilet paper. So he'd heard footsteps and he'd panicked and hid the acid in the hand dryer. Another pupil had then used the dryer and was sprayed with the face facility, and the acid went on the pupil's face. The magistrates in the first trial court acquitted the defendant because he had not subjectively foreseen any harm at all. He didn't even think about potential harm, he was just trying to hide the acid in the toilet. Now, this didn't go to the Court of Appeal, it was the Divisional Court, so that's important to note. And if you're unsure as to the Appeal Court, Court of Appeal, House of Lords, the Divisional Court, then what you must put there is just the Appeal Court. That means you've not got it wrong, you're not being specific, but you will get the credit. So the Appeal Court, or the Divisional Court, applied Caldwell to Section 47 and convicted the defendant. So the magistrates had misinterpreted it. Magistrates had applied subjective, which really was right. The assaults have always been subjective. However, no, not on this occasion. The Divisional Court said no. Caldwell objective recklessness now applied, and the ordinary, prudent individual would have foreseen a risk of harm from D's actions in hiding the acid in the dryer. So the Divisional Court had applied objective recklessness now to Section 47. So this is the popularity, the extension of the objective test. However, some of the judiciary then began to question the fairness and the validity of the objective test. And there were two reasons for this taking place, which was the issue of fairness, but also the potential loophole that became evident in some of the cases. So this is where, in short, the House of Lords and Court of Appeal realised they've done something wrong. What have they created here? They've created a monster, something that potentially could be very, very unfair. So, fairness, first of all. So we go, fairness. So this was the case of Elliot v C. Certainly in my classes I've mentioned Elliot and C lots and lots of times throughout the year. And the reason is this is one of the most unjust criminal decisions in criminal legal history. There aren't many decisions that are criticised quite as harshly as this case. So Elliot C, so this is pretty closely after the creation of the test itself. So this was a 14-year-old girl, but she had severe mental difficulties. So she had the mental age of a very young child, I think about 7 or 8, so very, very low mental age. And one night she ran away from home and she slept in a garden shed. In order to keep herself warm, she poured some spirit, some paraffin, over a carpet, thinking if she set that alight, but remember she's thinking as a 6, 7, 8-year-old, which is very, very young. She poured spirit and paraffin over a carpet, set it alight, thinking that would keep her warm. It did keep her warm, but it also set fire to the shed. She was convicted of criminal damage under the new objective test. The fact she did not see a risk of damage at all was completely irrelevant because the ordinary prudent individual would have appreciated the risk of harm, which is absolutely unjust. Of course she didn't see a risk. She has a mental understanding of a very young child. How could she appreciate a risk of harm? Yet the criminal law is willing to criminalise this young girl, young lady, of a criminal offence and a label that will stick with her for the rest of her life. It's completely unjust. Had she been tested subjectively, of course, she would not be guilty because she did not appreciate a risk, but this was the Caldwell test. Now, Lord Gough, who was the judge who delivered main judgment, held that he felt compelled to convict due to the constraints of precedent. So, a few fancy words there. What Lord Gough is effectively saying, and if you read the judgment, I mean, I've read the judgment and it's clear when you read the words of Lord Gough, what he's saying there is, I'm doing something that I really, really, really don't want to do. I'm doing something that I have to do, I'm compelled to do, but I'm only doing it because the boss has said, and it's not right. I'm being constrained by the system of precedent. And that's quite strong wording, really. That's really what the judge is saying there is, I'm convicting a girl who should not be convicted, and that is unjust. Now, clearly he couldn't say those exact words, but by saying he felt compelled to convict due to the constraints of precedent is a judicial way of saying this is absolutely not right, it's unjust, but I'm having to do this and it's not right. So she was guilty. So why was the case of Elliot considered harsh? Well, the defendant, with such a low mental age, didn't see a risk of damage, but not only did she not see, she was incapable of seeing any risk. So it doesn't matter what you do to that defendant, whether you give her a life sentence or a 10-year sentence or a 3-year sentence or the label, whatever you're going to give Elliot, it wouldn't correct her behaviour. She didn't foresee a risk and she never would. So it's pointless, the lack of justice. You're giving her a label which is unjust. You're convicting her of offence and giving her a prison sentence which is unjust. That will not correct her behaviour. So it's just not justice, in short. So the harsh precedent which had just been established in Elliot was strictly followed not too long afterwards in 1995 in Coles. This was another young defendant with a low mental capacity, again committing criminal damage or arson, same thing. The Court of Appeal strictly followed Elliot, saying that low capacity in terms of mental ability is not relevant to the OPI test. So it's not an accident what they were doing here. They were quite clear. The objective test was good, and if D did not see a risk of harm, that was irrelevant. Elliot and C, harsh, Coles, harsh. Now really, the nail in the coffin for me with objective Caldwell recklessness was Elliot and C. That's the first time the judges stood up and they realised we have done something absolutely catastrophic. We are criminalising a girl who is effectively innocent. It's unjust to convict her of a criminal offence, and this is where the question marks started to kick in. What have we done here? What have we created? What is this objective test? Is it unfair? Is it unjust? And this is where the ball started to reverse. And the court started to realise what we've done here is create a test which is not very good. However, they stuck with it even for a long while yet, well, for another 20 years. So the loophole then, this was another criticism that became evident in the Caldwell test. So, the Caldwell lacuna. So, now we've mentioned this again in the GN manslaughter handout because it's relevant there as well. But this was a potential massive problem with the Caldwell test, apart from it being unjust as above. Now, the Caldwell lacuna, I'll just jump down first, just go down to the Caldwell lacuna, and then we'll come back and revert back to the facts of Shimon. Now, most of you now, from the GN tests or your mocks, appreciate what the Caldwell lacuna was. Now, in actual fact, nobody ever established the Caldwell lacuna. Nobody ever escaped liability under the Caldwell lacuna. But as lawyers in the criminal law exam, we have to say this is a big problem and this could have been a big problem, etc. So, the Caldwell lacuna. Remember the test is your two limbs of Caldwell. Number one, you did not see a risk at all, but the OPI would. Or number two, you saw it and you ran it. The Caldwell lacuna is a defendant who doesn't tick either boxes. He falls somewhere in between, and if that could be proved or established in a court of law, he would escape liability, despite culpability. So this is where D considers a risk. So if he considers it, then he's not the inadvertent risk taker. He's thought about it. But then wrongly concludes that the risk wasn't there. D would fall outside the Caldwell test because he's not limb 2 either. Limb 2 is you see it and you ran it at the same time. This is a defendant at the time of running it did not see a risk. So he doesn't tick limb 1, he doesn't establish tick 2, limb 2. So this is a defendant who escapes liability. So I've just put an example there, it's just an example I made up. So the overtaking driver is overtaking on the motorway, he's coming off at junction 32. So he's approaching the bend where you come off near escape. Now he knows that if he pulls out, that if he doesn't quite find the right space to pull back in, if his car is not fast enough, that there is a risk that he could cause a crash. So that defendant is clearly not the inadvertent risk taker because he's thought about it. So that's gone. Limb 1 has gone. But then he sort of concludes that actually, no, he's a very good driver and his car is quite fast, that he should be able to negotiate to get back into the lane to be able to pull off at the junction. But yet, he does cause a crash and maybe causes some death. D would escape liability because even though he is more culpable than the inadvertent risk taker, he doesn't fit either of the tests. He thought about the risk, so that's not the inadvertent risk taker, but then when he ran the risk he didn't appreciate it, so he's not limb 2 either. Limb 2 is saw it, ran it, same time. This defendant didn't see it and run it at the same time. So just a little chart just to put that into context. If D considered a risk and the risk was there at the same time, that is the subjective limb of Caldwell. That's somebody who should definitely go to prison. Saw it, ran it, tick, same time. The defendant who did not consider risk at all, so very low culpability, and didn't see it at the time of the crime, so again, very low culpability, would be convicted under the Caldwell objective limb, which is unjust. He never saw anything, or she never saw anything, so that's completely unjust. Yet the lacuna is the defendant who does consider a risk, but then at the time of the risk taking did not see the risk. So you can see that defendant is the lacuna, because he doesn't fit that or that. To be convicted under Caldwell, you need to be that or that. This is a defendant who thought about it, yeah, so that one has gone, but at the time of running it, did not see the risk. So this is the loophole. If you could go into court and prove you thought about it, but then considered it wasn't there, you were found not guilty. Yet you are more culpable than this one here. This is Elliot and C. Saw nothing. This defendant did see something. He did perceive a risk, but then wrongly concluded. So this potentially was a huge loophole in the criminal law. So going back up then, this was the case which got closest to establishing the Caldwell lacuna, but nobody ever did. But again, like, we've got to sort of make this more significant for the exam. So Mr. Shipman, he had very limited martial arts experience, and what he decided to do was demonstrate these to his friends. So he's kind of showing off in front of like a shop window, plate glass window, and he was showing off his martial arts moves. So he was showing off his moves, and he knew there was a risk of breaking this window, but he thought about it, and he moved back. He intended to land a kick, so do some sort of move, just falling very short of the window, but instead his leg went straight through the window, so he smashed the whole thing. So he had considered a risk, because he'd only actually had a couple of lessons, so he wasn't really an expert. Students who have written this in the exam when I've marked it, always write in commas, was an expert, in inverted commas, because he actually wasn't very much of an expert. So he considered the possibility of breaking the window, because he wasn't an expert really. So what he'd done is move back in order to lessen or minimise the risk, and then he continued with his activities and then smashed the window. So he was charged with criminal damage, but he attempted to allege that he was the Caldwell lacuna, and if he could, he would escape liability, i.e. that he considered the risk and thought, well, actually, I'm not much of an expert, I could smash the window, so I'll move back a little bit, and therefore there was no risk. That's me being found not guilty. Yep, question there, legal principle. So why was Shipman unsuccessful in proving or establishing the loophole, i.e. why was he found guilty? Because actually Shipman was still this. When he moved back, what he had done is reduced the risk. When you reduce the risk, you still see a risk. So he'd consider the risk, he's not really an expert, he could break the plate glass window. When he moved back, he still saw a risk. Yeah, he'd lessened it, he'd reduced it and minimised it, but he saw a risk, he'd lessened it, but he still saw the risk and continued. So he was guilty under the subjective limb of Caldwell. So he was the closest defendant that ever tried to establish the Caldwell lacuna, and indeed it failed, and most likely rightly so. So the lacuna was also attempted in the case of Merrick 1995. So this was the second case that got close, or very close, to establishing the Caldwell lacuna. So this was a defendant. He'd gone into various houses and he was removing electrical cables from houses, but he was leaving them exposed, so live wires, for approximately 6 minutes. Now, leaving a live wire exposed is extremely dangerous. If any person touches a live wire, the chance of death is almost definite. So he'd left these wires exposed for a number of minutes, approximately 6 minutes, and he was charged with criminal damage whilst endangering life. So Dee had argued that he was, again, the Corwell lacuna, that he'd thought about the risk. Yeah, okay, live electricity is very dangerous, but because I've left them live for only a short amount of time, there was no risk at the time that he did and ran the risk. If he could prove that, then he would be the Corwell lacuna and he would escape liability. However, what the Court of Appeal argued is that he was still guilty, and they upheld the conviction because what he had done by leaving the wires exposed for just 6 minutes, he had minimised the risk. And if you minimise the risk, as Shimon, you're just lessening the risk, but you still appreciate it is there. So the lacuna failed, his argument failed. Why? He saw a risk, he knew he was exposing live wires, and he still ran that risk. Yes, he lessened it to 6 minutes, but he still appreciated the risk was there and therefore was liable. And now, because Caldwell has gone, we haven't quite got there yet on the handout, but because Caldwell has now gone, nobody will ever establish the Corwell lacuna. So that is settled now in history. Okay, so because of the cases, the unfairness, Elliot and C, the lacuna, the courts soon started to realise that in fact the objective test, there were problems with it, it was unfair, it was unjust, lacuna, etc. So the court started to pick up that actually maybe the subjective test was the fairer test of liability, which of course we know is the exact case. So what I found is case by case by case. The Court of Appeal, sometimes the House of Lords, were trying to return back to SR, subjective recklessness, trying to go back to Cunningham type recklessness. So it was a gradual return to subjectivity, which is right because it's the better test. So these cases here are just showing that return. So Satnam 1984. So Dee, who was a 30-year-old, was accused of raping a 13-year-old in the back of a car which had been driven round by another defendant. They'd claimed that she'd consented or that they thought she had. The Court of Appeal quashed the conviction due to a misdirection, but held that consent in rape must be tested subjectively. So where you've got the spare bullet point there, what we need to put there is rape dash SR, subjectively tested. Now the context to that is this offence of rape and many offences, because the objective test became so prevalent, so popular, everything was being tested objectively, and even consent in rape had been tested objectively, which is unjust. Rape is such a massive label, massive sentence. It's up there, just close to manslaughter, murder. You've got to test Dee's foresight, Dee's culpability, Dee's perception. There's no way in the world that you should ever be testing Dee objectively. So that had happened previous to this case. However, this case showed the Court of Appeal had acknowledged objective recklessness was unjust, and now rape and consent in rape had to be tested subjectively. And that's a tick, that's got to be right, it's got to be subjective. Another case which showed a return to subjectivity was the case of Spratt, 1991, which was a Section 47 case. So the defendant fired an air pistol randomly outside an open window where there were kids in the street, and it hit and injured the victim. Dee argued that he'd been unaware that there were any children outside, just randomly fired this gun outside the window, brackets which seems unlikely. However, Dee was charged with Section 47, and again, remember the previous case is K, and DPPV and K had said that ABH was objective. Court of Appeal quashed the conviction, suggesting that Roskell's obiter in Seymour, whereby Roskell had said everything's objective, unless Parliament had said otherwise, was not intended to overrule Cunningham, i.e. they've got it wrong. Court of Appeal overruled DPPVK and added that subjective recklessness now still applied to the offences under the OAPA. Again, spare bullet point there, section 47-SR, subjective recklessness. So again, it's just the Court of Appeal saying, actually, look, what the House of Lords has done is wrong. The assaults have to be tested subjectively. Which is right. They should be tested subjectively. Savage and Parmenton, 1992. This was a joint appeal. So you have the facts of one or two of these on the assaults handout, depending on which handout you're using. And it gets a judicial reasoning, a linked case, so you don't necessarily need the facts. So it was a joint appeal heard by the House of Lords, and this time the House of Lords were reviewing section 20 GBH and wounding and section 47 actual bodily harm. And in Savage and Parmenton, the House of Lords were unanimous in their verdict that both assaults had to be tested subjectively under Cunningham. So spare bullet point, the OAPA assaults all tested under SR. Which again is right, you've got to test the assaults subjectively. Adamarco, which is one of the cases that we know very well from admissions and from GN, which was the anaesthetist. We took various minutes to realise that the machine wasn't working, the patient was blue, the machine was flashing, alarm had gone off, etc. So there's various indicators that the patient wasn't being administered sufficient oxygen. Now remember, the previous decision here was Seymour. Girlfriend, boyfriend, caravan. Yep. That was the House of Lords saying that invol manslaughter, GN manslaughter, was now to be tested objectively. Adamarco overturned that. Now, you've got to be careful how you word this, because this is not the same as the cases above. The cases above showed a return to subjective recklessness from objective recklessness. So objective, 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 now subjective. This one's quite a different argument. It's objective, just removing objective and replacing it with something different. So it's not a return to subjective, it's just a removal of objective. So I suppose in short, removal, 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 or removal of objective recklessness, but to something else. So whereas the ones above are a removal to subjective, this was a removal back to gross negligence manslaughter. Just be careful how you phrase it. They're all removals from OB. OB had now gone, it's going in the bin, it's not very good, it's not being followed. These returned to subjective recklessness. This returned to GN. So on your spare bullet point there, in Adamarco, the House of Lords removed OR and replaced it with GN. So GN was revived and brought back. Then LIDAR, which is the SRM case, subjective reckless manslaughter case, which was the gang of youths in the high performance Range Rover car with the bouncer hanging in, half out of the vehicle. And the vehicle sped up, knowing he was half hanging out of the vehicle, and he was run over by the wheels and he died. Remember, invol manslaughter, referred to above, invol manslaughter had been tested objectively. This case return to a subjective test. So again, it's the same argument as above, is removal of ob to something new. Removal of ob to subjective reckless manslaughter, which actually is a subjective test. So all cases on this side even are showing a removal of objective Caldwell to something different, either subjective recklessness or GN or something different. So here it was an involved manslaughter case, no longer objectively tested but now subjectively tested, i.e. SRM. Okay, so there was a gradual return, case by case by case, back to the law before Caldwell. The judges, the House of Lords, Court of Appeal had realised that they had made a test which was very unfair. So the next section then is the return back to Cunningham only 2003. So this is where the House of Lords had the opportunity and took the opportunity to rectify and correct the Caldwell decision. So the return to Cunningham in 2003. Cunningham never went anywhere and subjective recklessness never went anywhere. It coexisted, but of course it suffered from the popularity of objective recklessness, so it was less frequently used. So although subjective recklessness never disappeared, it suffered from the short-term popularity of OR, objective recklessness, which took over. However, the House of Lords decided at long last to overrule Caldwell and Caldwell recklessness in 2003, and in doing so had to use the practice statement to remove their own decision in the practice statement of 1966. Objective recklessness has now been abolished because of this new decision. So, using the practice statement is major news. The House of Lords have used it on very limited occasions in the criminal law, and when they have had to use it, it has to be for a really serious reason. So using it the couple of times that they have, this is a major precedent, and they had to use it in order to overrule their own decision of Caldwell. Okay, so this is the key case which governs the law of recklessness today, which is the case of RV G&R, which is 2003. So this is a case which is on the precedent booklet, so you might recall the facts of the case. So these were two young boys, G&R. Obviously, because it was youngsters, their names weren't revealed, hence referred to G&R. So in August 2000, which is when it actually happened, 11 and a 12-year-old boy were camping away from home when they entered the backyard of a supermarket and set alight to some newspapers in some wheelie bins. It was the back of, just for information, Co-op in Newport Pagnell, so they'd gone behind this Co-op supermarket, and in the wheelie bins they'd seen some papers and stuff and they'd set fire to them. What they didn't appreciate is that fire on concrete could spread. But the fire did spread from the concrete to the building and it burnt down the whole of the supermarket, causing over £1 million worth of damage. Both boys declared that they genuinely believed that the fire could not spread across concrete, which is a genuine assumption. I'm no fire expert, but I did not appreciate until reading this case that fire could spread across even concrete. So looking at their culpability, they're 11, they're 12, they did not appreciate that this would spread. Now, if you're going to apply Caldwell, they will be guilty. Now, clearly they are culpable, but remember the label. The label that you're giving these young boys and the sentence will have to be a severe prison sentence. So you've got to bear that in context. So the trial judge in the Crown Court had to apply Caldwell because that was the law at the time. He applied Caldwell and convicted under the objective limb because the ordinary prudent individual would have appreciated a risk of damage to property. So it didn't matter what these boys thought, foresaw, their age. The fact is, the ordinary prudent individual, i.e. the adult juror, would have foreseen a risk of harm or a risk of damage to the property. So they appealed to the Court of Appeal. Now the Court of Appeal dismissed the boys' appeal. They had to, because the Court of Appeal are below the House of Lords, and the binding precedent was Caldwell, which was House of Lords. So the Court of Appeal had no discretion. They had to follow and adopt the Caldwell direction, and said the boys' appeal was dismissed and that the boys were convicted because the OPI would have foreseen a risk of damage being caused to the property. But then they certified a question to the House of Lords, and we've seen that before. Certifying a question is where the Court of Appeal is stuck, effectively. Obviously you wouldn't word this as such in the exam, but where the Court of Appeal are really not sure or stuck or want clarification on a point of law, and they certify a question to the higher court, the House of Lords. And so they certified a question and asked at what point should they be convicting a defendant under the objective test. The House of Lords, when they received the certification, overruled Caldwell and held that in any such case of criminal damage, that the defendant in question or defendants in question must be tested subjectively had they appreciated the risk of damage. So in short, what the House of Lords have done is bitten the bullet and said, right, we've got this wrong. Back in 1981-82, 21 years before, Caldwell was wrong. It was our decision, it was our creation, but it was wrong. So they overruled Caldwell, and they, I'd like to say reinstated, but it had always been there in the background, but confirmed that subjective recklessness is the only right and living form of recklessness. So Lord Bingham was the main judge who delivered judgment, agreed that the law lords had taken the law in a wrong direction when they decided Caldwell. So that's kind of a fancy-ish type of way of saying we got it wrong. When we created Caldwell and the test, we got it wrong. Parliament, under the Criminal Damage Act 1971, had never intended to go against Cunningham, and presumably subjective recklessness was the test all along. What Lord Bingham was doing there is going right back to the page 2 on the handout, and he's looking at the Law Commission report, he's looking at the fact that at the time only SR existed, and what he's saying in short is, yeah, it was Cunningham all along. Cunningham only existed when the Act was created, so when the Act said recklessness only, it meant Cunningham. Yep, so the House of Lords had taken the law in a wrong direction when they decided to create a second test. And he's right, it was clear that the Act meant Cunningham, just didn't say it. The House of Lords also then confirmed and favoured the definition of recklessness by the Law Commission report in the draft criminal code, which was SR. So what they're saying is SR is the right test. A person who acts recklessly, where he is aware of a risk and in circumstances known to him it was unreasonable to take that risk. Again, it's all very wordy, but the House of Lords are saying, look, we like the definition of subjective Cunningham type recklessness, where he saw a risk and he still ran the risk. Okay, so what was the majority received in this judgment of RVG and R? The judgment was a unanimous judgment, which means all 5 law lords agreed Caldwell had to go. Which I agree, it's right. Caldwell was bad law from day one. So they all agreed, so it's a very strong judgment, strong verdict. All 5 agreed. So, again, we've got to look at the reasoning of the law lord. So this gets us judicial reasoning for an essay. And the leading judgment in GNR was delivered by Lord Bingham. It gave 4 main reasons in order to justify why Caldwell had to be overruled, why it had to go. And as you'll appreciate with Hassan and duress and other areas of law, wherever the House of Lords make a major judgment, they have to justify why they are doing that. That's just how it works. They have to justify why they're making such a major decision. And that's what they did. So the 4 main reasons stated by the House of Lords, or Lord Bingham, to note. So Lord Bingham talked about the Criminal Damage Act 1971. And what Lord Bingham said was that in Caldwell, which was still his court, still the House of Lords, but of course different law lords 21 years before, but what he acknowledged, Lord Bingham acknowledged, is that the judges, the House of Lords in Caldwell, had misread the Act, the Criminal Damage Act. And we know that. They'd completely misread it. And therefore, the House of Lords now had a duty to correct that mistake. The Criminal Damage Act just used the words reckless, but of course it meant Cunningham. Because the Law Commission report mentioned Cunningham, only Cunningham existed. So, Criminal Damage Act 1971, just a note there, Lord Bingham confirmed that the House of Lords had misread the Act. Subjective recklessness was intended all along. Yes, the fault is Parliament because they should have said that in the Act. However, it was clear to everyone that from day one, criminal damage, which is where the problem started and ended, was meant to be subjectively tested. Number 2, culpability. So the law lords, or Lord Bingham, justified what they were doing here, which is removal of Caldwell, removal of objective recklessness, and he stated that serious crime, such as criminal damage, serious crime required culpability. And the problem is Caldwell did not demand that. Caldwell is saying if you don't see anything, you're still guilty. Elliot and C, learning age of 6, 7, 8, you are guilty. What Lord Bingham is saying here is any serious crime needs culpability, and this test we are looking at, Caldwell, does not need it, therefore bin. It had to go. Lord Bingham then further reasoned by looking at the 2 decisions of Elliot and C and Coles. So Elliot and C, Elliot is the young girl with the learning difficulties who set fire to the shed. Coles was the second defendant who was a youngster who was also charged with criminal damage. Both did not see the risk of harm because of their mental incapacities. Lord Bingham talked about both, and he said that Caldwell led to massive unfairness, mass injustice, and pinpointed and attached that to these 2 cases. And he used that as a justified point to say that's why Caldwell had to go. So Elliot and Coles, Lord Bingham said that Caldwell led to mass injustice, in particular these 2 cases, and therefore it's another reason why the Caldwell test had to be removed. Finally, Lord Bingham then made reference to academic opinion. And so he looked at the various academics that had written articles, books, etc. on the subject content of recklessness. And the House of Lords, or Bingham, acknowledged that the judicial and academic opinion on Caldwell was pretty low. There was lots and lots of criticism of Caldwell, and as this criticism mounted up, it was time to admit they'd done wrong and they had to reform it, i.e. objective recklessness had to be overruled. So academic opinion, House of Lords, Lord Bingham acknowledged there had been lots of criticism, and it's another reason why it had to be overruled. So 4 very strong lines of reasoning why the Caldwell test had to go, and that's exactly what happened. So ultimately, objective recklessness was abolished, and it was replaced with, well, not replaced because it was still always there, but replaced with the one test that had always been there since 1957, subjective cunning and recklessness, which is on balance deemed the fairer test of liability. So what has happened since GNR, so life after GNR? The answer is nothing really. What's happened since GNR is everything now is tested subjectively if recklessness applies, which is the fairer test of liability. Just 2 cases remain, and these 2 cases were caught within the cusp of the period of 2003. So they were decided before GNR and they appealed just after. And these 2 cases really sort of settle and confirm where we are with recklessness. So in Cooper 2004, the defendant lived in a hostel dedicated to people with mental health problems, and what he'd done is set fire to a mattress in a hotel, but he was trying to harm himself. The fire was pretty small and it was quickly put out and extinguished, and there was only damage to the mattress only. And he was convicted of criminal damage or arson whilst being reckless as to endangering life. And he was given a life sentence under Caldwell. That seemed really, really punitive, really harsh. Small fire, yes, it could have spread, but he's got mental issues and a life sentence seems very harsh. So his mental problems were irrelevant at the point of trial because he was tested under Caldwell, and the test is the OPI. Not what Dee saw, not about Dee's mental issues, incapacities, it's about the OPI. So he was convicted and given a life sentence. On appeal, so the trial was before GNR, but he appealed just after in 2004. And on appeal, the defendant was acquitted. They applied the new precedent under GNR. The test was now subjective, and as D. Cooper did not subjectively take an unjustified risk, he was found not guilty and he was acquitted. So much fairer decision. And then in Castle, same thing again, decided before GNR, appealed straight afterwards. The defendant broke into an office and started a fire. There were flats just above the office and they were unoccupied. Nevertheless, the fire spread and Castle was charged with arson or criminal damage whilst being reckless as to endangerment to life. Again, the trial judge had to, because that's his job, he's lower than the Court of Appeal and House of Lords, had to apply Caldwell and convicted because the defendant and his perception were irrelevant. The decision was about the OPI, the ordinary prudent individual's perception, and the ordinary prudent individual would have foreseen a risk of endangering life from setting a fire in the office, which could spread. So then, of course, GNR occurred. So on appeal, applying the new precedent decision under GNR, the conviction was quashed, as Castle was unaware that there were any flats above the office. He had not been reckless as to the endangerment of life, i.e. he was tested subjectively under Cunningham, under the now sole test, and he subjectively did not see a risk of endangering life. Again, it's a life sentence, so that's again a just decision. So we've gone full circle really. We started with subjective, we started with Cunningham, and then now we've gone back to that, which is the better and fairer test. So those 2 cases confirm on appeal that Cunningham is now the only test, and it's a good test, or the fairer test. So final question, what's the future of recklessness? Some questioned at the time of GNR whether it was just talking about criminal damage and Caldwell, but it's now been confirmed or agreed that objective Caldwell recklessness has now gone, so it's been removed forever. And the future of recklessness is there is just one type, and that is subjective Cunningham type recklessness, which is on balance the fairer test of liability. It examines culpability, and it's right that that is the only test. So all that could happen really is this was codified into an Act of Parliament, but really, in short, critically analysing recklessness. Now recklessness is now good law. It's been sorted, Caldwell has been removed, and Cunningham is the sole test, and it is a fair test.